Hi, everyone. We're going to go ahead and get started with webinar Orders for Protection and Harassment Training Orders 101. Before we begin, just a little bit of information about the Standpoint webinar series. So Standpoint is a statewide organization. We're a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who interact with survivors. We do this by facilitating trainings and answering calls to our action line. Examples of the trainings we do are the annual New Laws training throughout the state of Minnesota, monthly webinars for advocates, and other trainings by request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m. It is through our action line that our attorneys provide legal advice to survivors, and our advocates connect with callers with resources, safety planning, listening, and help callers identify possible options and next steps. We are here to assist you, so please reach out. And without further ado, I will turn it over to Raina Alexander, who will be the presenter for today's webinar.
Thank you, Tracy. So I'm Raina Alexander. I'm the executive director here at Standpoint. And I've been here at Standpoint for over 14 years and working within the domestic violence and sexual violence movement for over 21 years. And I have an expertise in protective orders. Also, some of you may be familiar with my presentations on confidentiality and privilege, because I also train a lot on that too. And we have a different webinar on those issues. So check that out if you're interested in continuing to hear my voice after this training. So today I'm going to talk with you guys about orders for protection, harassment restraining orders, and just a little bit of DANCOs stuff at the very end, mostly because while arguably, if you don't, by the end of this presentation, you'll understand the difference between all three, but a lot of times the folks that we talk to don't understand the difference, and so it's helpful that we understand so we can help make sure that the folks we are working with understand. So if I can get my slide to advance, that would be helpful. There we go. So we're going to talk about three different types of protective orders that exist here in Minnesota. So there are orders for protection, or otherwise known as OFPs. Those are created under Minnesota Statute 518B.01. You can get an order for protection. You have to show two things. You have to show that the petitioner, the person applying for the order, is a victim of domestic abuse, and we'll talk more about what that means. But you have to show they're a victim of domestic abuse and that that domestic abuse has been committed by a family or household member. Both domestic abuse and family or household member have a specific statutory definition, so we'll talk about that in a minute. We also in Minnesota have harassment restraining orders, which are known as HROs, or for those of you in Hennepin County, HAs. I have no idea what the A stands for or where it came from, but I can tell you that in Hennepin County, they use HA. Harassment restraining orders are found in Minnesota Statute 609.748. They are in the criminal statutes, but are a civil protective order. A violation is a crime, but the order itself is a civil order. To be able to get a harassment restraining order, a petitioner has to show that harassment has occurred, and that has a very specific definition under statute. But a harassment restraining order does not have a relationship requirement. So you can get a harassment restraining order against anybody. Unlike an order of protection, we got to have that family or household member relationship, HRO, against anybody. And then finally, there are domestic abuse no contact orders, or otherwise known as DANCOs. Those are found in Minnesota Statute 629.75. And these are in criminal cases. They are an order that is issued by the court only in criminal cases. While I don't have a bullet down here for this, you do have to have a family or household member relationship, but we'll talk a little bit more about DANCOs when we get there. So that's what we're going to cover today. We're going to start off talking about orders for protection. So orders for protection, again, first of all, you got to be able to show that domestic abuse has occurred. So what is domestic abuse? So we look to Minnesota Statute 518B.01, subdivision 2, A, and that gives us our definition. And under the statute, it breaks it down into 3 parens, 1 through 3, but the last 3 things are all included in parens number 3, so I like to break them out. So I always think of domestic abuse as meaning 5 things. It is, or it can be physical harm, bodily injury, or assault. It can be creating fear of imminent physical harm, bodily injury, or assault. So threatening somebody or doing things that make somebody feel afraid that they're going to be physically harmed by that other person. Statute includes criminal sexual conduct, 1st through the 5th degrees, as defined in our criminal statutes. It includes terroristic threats, which I need to modify here because the language in the statute changed a couple years ago to threats of violence. But I still have terroristic threats because mostly we still call it that. And then finally, interference with an emergency call. And I do like to remind folks that while often in our field and law enforcement and prosecution, we will truncate this to interference with a 911 call. It is actually an emergency call is the language in the statute, and in the definition of emergency is broader than simply calling 911. So it can encompass more things if a call was interfered with. It could arguably by the statute include I'm getting assaulted and I call my mom trying to get help and that call is interfered with and I'm calling to get help, right? So that could be an emergency call that was interfered with. So it's a much broader definition, and although we truncate it to a 911 call, we need to remember it's broader. So really important things to remember when looking at this definition of domestic abuse. It includes a lot of things, but one of the major things it doesn't include is crappy parenting. And so I always like to remind people that being a bad parent is not necessarily domestic abuse. Driving with your children in the car drunk, bad parenting, don't do it. Child protection doesn't like that stuff. If you get arrested, there's a whole bunch of problems that come along with it, right? Don't do it. But it's not domestic abuse, okay? Doing drugs around your children, bad parenting, don't do it. Child protection, again, is going to get involved, but it isn't domestic abuse. Leaving needles around the house, don't do it, bad, but it's not domestic abuse. And so you have to think about how does the respondent's behavior fit into one of these 5 categories. You got to be causing physical harm, creating fear of imminent physical harm. And if you're going to try to go under that category, especially as it relates to a child, who's going to testify to that? And how is that evidence going to get in? And how are you going to show the court, right? So these are things that are really important to keep in mind when we think about what is domestic abuse, right? So holding tight to our 5 pieces of definition that go for this. All right, so we have to show that domestic abuse occurred. The next thing, we have to show that domestic abuse has occurred to that petitioner by a family or household member. And so this is also the definition in 518B.01 subdivision 2. And we have a very broad definition of family or household member here in Minnesota. So it includes spouses and former spouses, parents and children, blood relatives, lived or used to live in the same house together. And that Minnesota has read that fairly broadly. I know that there are some counties who will include under that definition cellmates. So if you're in prison or you're in jail and you have a cellmate, you are living in the same house together. There is case law that says if you are renting a room in somebody's home that you are living or used to live in the same house together. However, if you are living in apartment A and the person who you want to get the order for protection against is in apartment B, that does not count as living in the same household together, okay? So if you're separate apartments is not living in the same house together, but if you're renting a room in a house, it has been found to be living in the same house together. If somebody has a child, they have children together, the respondent and the petitioner, there's a pregnancy in common, or lastly, they are a current or formerly dating partners in a significant romantic or sexual relationship. So Minnesota is a very broad definition. It includes all sorts of LGBTQ plus relationships. The one that it probably doesn't include that sometimes we hear about over here at Standpoint would be often in-laws. So a mother-in-law, a sister-in-law, unless they have lived in the same house with their in-law, they're not going to be included in this definition, but otherwise a very, very broad definition here in Minnesota. I do want to remind folks, I forgot to say this in the beginning, please, if you have questions, please feel free to type them in. Tracy will interrupt me when appropriate and ask me the questions, but if you have questions, please ask them. Feel free to, or if you think of stuff later, of course, Standpoint is always here to support you in this work. Okay, so we've determined, as advocacy, you feel that you've got domestic abuse by a family or household member against the petitioner. And so what's the relief the petitioner can receive? So under an order for protection, the relief is really broad. There are lots of options for the petitioner. The petitioner can get an order that says that the respondent cannot commit further acts of domestic abuse. It can exclude the abuser from the shared residence or from the petitioner's residence. It can exclude the abuser from a reasonable area around the house, from the workplace, or limit access to a workplace. Order the abuser not to contact the petitioner, either in person, by phone, by letter, by a third party. It could award custody or modify or return custody of the children. And I do have a note here that while that can be ordered in an ex parte hearing, it will end up requiring, an ex parte order, sorry, it will end up requiring a hearing. So the relief that is on this slide and on the next slide, that is all relief that a petitioner can receive in an ex parte order. So an order that happens without a court hearing and without notice to the other party. And I'll talk a little bit about the different types of orders after we get through the relief that's available. But this is all relief that one can get in an ex parte order without ever having a hearing. There's a variety of pet or companion animal relief, either care or possession or control, or ask that the respondent not be able to physically abuse or injure any pet or companion animal. Asking the abuser not to make changes in insurance coverage or dependent coverage. Petitioner can ask for return of house or car keys, or to recover those keys when the protective order is served. Ask that the sheriff or law enforcement go with the petitioner to the home to either remove the respondent or to help recover property. And also finally allowing the respondent to only remove the respondent's property with the sheriff or the police present. I will remind folks that this is if folks are trying to get when the respondent is trying to get this piece of the property part, this is narrow. This is like, what do you need right now to be able to like brush your teeth and brush your hair and go to work tomorrow or whatever, right? This is not like to help the respondent get their TV and their couch and all of that kind of stuff. That is absolutely not what this piece is looking for here. So all this relief on this slide and the slide before, one can receive ex parte without a hearing. If the petitioner would like further or broader relief, there is additional relief that the petitioner can receive with a hearing. And that would be, there's restitution, they can establish or modify parenting time, order supervised parenting time, child support, spousal maintenance, specify what property that the parties have in common, such as a car. This is when I remind folks, like, this is really like the property that the petitioner needs to like work the petitioner needs to do something really important in their life. Like, I mean, this is not, again, a time to, in general, argue over couches and TVs. This is like, I work from home, I need my laptop. There's medication that I need. I need birth certificates. This is where that kind of stuff. Ordering that neither party sell any property or damage property or use it for a loan, ordering the abuser to complete a counseling or treatment program, or finally, ordering any other relief necessary for the protection of the abuse for either the petitioner or the children. So this is a super broad category, and a lot of stuff could go into here. Things to think about is staying away from daycare as it relates to the children often falls into this category. Another option, especially for immigrant folks, it may be getting passports back, visas back, other immigration-related documentation often falls under this category. So this is a good place to ask for those types of documents back. Or another option is if somebody is in Section 8 housing, so they're receiving some sort of government funded, but specifically Section 8, and they have a voucher, the Public Housing Authority has to abide by any court order. And so if the court orders that the voucher goes to the petitioner, that helps give some clarity to the Public Housing Authority if you have a voucher that had both parties' names on it. So that can be really helpful. So that's another good thing to think about in that other relief. The court does need to make a finding that it is necessary for the protection for the petitioner or the children. So keep those things in mind. If the petitioner would like to ask for supervised parenting time, I will strongly encourage you as advocacy to help the petitioner figure out what is that going to look like, and to have a plan and make sure that whoever that plan, like if we're using grandma to be the supervisor, does grandma agree to this? Is she okay with it? Making sure, or we're going to go to a parenting time center. What center is it? So making sure that there is a plan that you can offer, or that the petitioner can offer to the court. The court is much more likely to accept something if there is already a plan. So help the court out and have that conversation with your client ahead of time and figure out, if we want to do this, that's great. What does it look like? Okay, so keeping that in mind. And remember, all of this is relief that one can only receive after a hearing. Okay, so if somebody requests any of this type of relief, a hearing is going to automatically be scheduled because it's required under statute. So the other relief one can get in an ex parte order, and a hearing will not necessarily be scheduled unless somebody asks for it. If any of this relief is requested, a hearing has to, under statute, be scheduled. I don't know why this slide is in here, so I'm sorry about that. Okay, can I file my order for protection in Minnesota? Minnesota, per our statute, says clearly that we do not have any residency requirements for the petitioner. And what that means is so the idea behind this is if I flee to Minnesota for safety reasons, okay? So I left Wisconsin and I came to Minnesota, and I did so because I'm in danger and I want to file an order of protection to help protect myself. I can do that. So I can leave Wisconsin, I can be in Minnesota for literally a hot second. And if Minnesota is where I am planning on making my home, like I'm moving here, okay, but I need a protective order to help keep me safe, I can do that. I don't have to be in Minnesota for a certain amount of time. In dissolutions and divorces or in custody actions, you need to be in Minnesota for 6 months. That's not true in an order for protection. But they do have to be planning on making Minnesota their home. They can't come from Wisconsin, hop over to Minnesota, file an order of protection, and then go right back to Wisconsin. Like, that's not going to work. If you're going to live in Wisconsin and use a Wisconsin address, then you got to file in Wisconsin. Can't file in Minnesota. Okay, so you gotta be living in Minnesota. The respondent does not have to live in Minnesota. There does need to be sufficient contacts with Minnesota, and we do have some case law that talks about how the petitioner is in fear here in Minnesota, and the respondent has had some sort of minimum contacts with Minnesota, and that could potentially be in the form of respondent has been calling the petitioner while the petitioner is here in Minnesota and making threats or scaring the petitioner. Potentially. There's a lot of strategy and thought process that needs to go into if you're going to file an order for protection or any protective order against a respondent that does not live in Minnesota. There's enforcement issues, there's a variety of things. So if you have questions around that, please reach out to Standpoint. But do know that the respondent doesn't necessarily have to live here in Minnesota to be able to file an order for protection against them. What county can the petitioner file in? This is laid out in statute. It's otherwise also known as venue. The petitioner can file an order for protection in either the county that the petitioner or the respondent reside. And again, that's that individual's desire to make a permanent home. They can file in the county where the abuse occurred, or they can file in the county where there is another family court proceeding that has occurred with the abuser. So those are the 3-4 counties that somebody can file in. I sometimes get asked if somebody can file in the county that they work in. And my response is, well, if the petitioner or the respondent live in that county they work in, or the abuse occurred in the county they worked in, or they have a family court proceeding that occurred with the abuser in the county that they also work in, then yes. If the only connection to that county isn't one of these 3 bulleted points, then no, you can't file in the county you work in. You can only file in the county where the petitioner or respondent reside, where the abuse occurred, or where there is another family court proceeding that has occurred with the abuser as the other party. Okay. So those are the counties that a petitioner can file in. Who can file for an order for protection? Any adult victim, and adult means 18 or older, of domestic abuse can file against a family or household member. Statute says that a minor age 16 or older, so 16 or 17, can file against a spouse or former spouse or a person with whom the petitioner shares a child, and they can do that on their own. There is some language in there about the court has to make a best, like the minor is of sufficient age and maturity, and that it's in the best interest of the minor. So it's not just a bing, bang, boom. But so the court does have some additional things it has to think about when we filing against a spouse or former spouse or somebody who they share a child in common with. All other minors, those are the only options. We don't have any other language for other minors. All other minors have to have a parent, relative, or guardian, or a reputable adult age 25 or older to file on the petitioner's behalf. All right, there's no other option. And since Minnesota doesn't really have emancipation, I have no idea what that would look like if somebody was emancipated, they had a court order, and how that would play out. So I don't know, because this is the language that's in our statute that I got. So. All right, I've already kind of alluded to the different types of protective orders. So in Minnesota, we have ex parte order for protection orders that one can obtain. Ex parte is Latin. Lawyers love Latin because then you have to hire lawyers for us to explain to you what the Latin means. We're not dumb, we get it. So ex parte means by one party without notice to the other party. And an ex parte order in the law is extraordinary relief. You are asking the court to do a really, really, really big thing because, right, we have Constitution under the United States Constitution, both the 5th Amendment and the 14th Amendment guarantee us due process. But here, the court is issuing a protective order, potentially removing somebody from their home without giving them an opportunity to even be heard because the allegations are so serious that we need to do something to protect that petitioner right away. And that depriving the respondent of a short amount of due process is not as important as protecting the petitioner. right? So when you're applying for an ex parte order for protection, the petitioner needs to allege an immediate and present danger of domestic abuse as defined. So those 5 things that we talked about earlier. So got to show immediate and present danger of domestic abuse on an ex parte order. One of the oddities in Minnesota, I worked in a couple of other states and we did not have this, but in Minnesota, an ex parte order for protection can become a final order without a hearing if the petitioner requests that specific limited relief, those first 2 slides of relief that we talked about, and neither the respondent nor the petitioner request a hearing. And that now, I used to have to say that Anoka County always held a hearing, but now that is changing in Anoka County, and they are tending more to follow this process of where they allow, if it only requests the specific relief and no one asks for a hearing, then no hearing is scheduled. So Anoka County is moving towards that. The rest of the state follows this. Otherwise, somebody gets an ex parte order if they requested that a broader relief on the 3rd slide, or one of the parties, either the respondent or the petitioner, asked for a hearing. Then the petitioner would end up with some sort of final order, either after an agreement or after an evidentiary hearing. Okay. Tracy, are there any questions at all?
No, there are no questions at this time.
All right, thank you.
You're welcome.
So what should a petitioner be filing when they're filing for an order for protection? The petitioner files a petition and affidavit for ex parte relief. Those documents you can find on the court forms website. They would file the petitioner information sheet, and they'll file the law enforcement information sheet. Okay. So they fill out all that information, and then they take all of those documents, the petition, the affidavit, and the other paperwork in every county but Hennepin, and they'll present it to court administration. And then from court administration gives it to the judicial officer, and then if the judicial officer signs the order, then that's given to law enforcement for service. Okay. In Hennepin County, it happens a little bit differently, and it depends on if you're at a community-based program or you're going through the Domestic Abuse Service Center. If you're at a community-based program, mostly you're going to fax them over to the signing judge of the day over in family court. And then the Domestic Abuse Service Center will, if it's going through them, then they walk it up to the signing judge of the day, is how that happens over in Hennepin County. So they just have a little bit of a different process. For court fees, there are no court fees for an order for protection or for either side, for either the petitioner or the respondent. And that changed just a couple of years ago about the respondent. So nobody's paying any court fees, no matter if you're a petitioner or a respondent. And how long does an order for protection last? It's often about 2 years. The statute says that the order can be that it can be up to 2 years as the court deems appropriate. So the language in the statute allows for an order for protection to be longer or shorter than 2 years if the court deems it appropriate. I have definitely seen cases where you have some pretty horrific abuse that occurred before the protection order is filed, and I have seen judges on the get-go issue a 5 or 10-year order after a hearing because of the severity of the domestic abuse that the petitioner experienced. So it's definitely an option. It is a rare one. You need to use some pretty significant discretion in asking for it, but for certainly the court can definitely do that. It's allowed under statute. And then we also have 50-year orders for protection, which we'll talk more about in a little bit. Orders for protection have very specific timelines for service, and it is really important that as advocacy, you know what these timelines are, because if a timeline is missed, the order will expire and your client will not have protection from the order for protection and will have to reapply. So very important to pay attention to the timelines for service. So if an ex parte order is not issued, then the court is supposed to schedule a hearing in 14 days. The language in the statute says shall or must. It's required language. Now, we do allow petitioners to decide that in the protection order, in the order for protection paperwork, to tell the court, if my ex parte is not granted, I do not want a hearing scheduled. So there is the ability for a petitioner to make a choice here about whether or not a hearing is going to be scheduled or not if their ex parte is not issued. And for some petitioners, they want to try to get the order for protection, but if it was denied, that puts them in way too much danger to have a hearing, because then the respondent gets notice, obviously, that they tried to get an order for protection, and that could put them in a lot of danger. So, but statute does have this shall language about issuing a hearing in 14 days if the ex parte is not issued. If the ex parte is issued, then and the petitioner only requests that limited relief, just those first two slides of relief, no hearing is required. Unless the respondent requests a hearing, and then the court has to schedule a hearing within 10 days after the respondent makes their request. Now, the respondent has, and I don't have this on here and I apologize, the respondent has 5 days from the date of service of the ex parte order on the respondent to ask for a hearing. So respondent has 5 days to ask for a hearing after service, and then the court has to schedule a hearing within 10 days after it receives the request. This one is really important. If there is no personal service of that ex parte order within 14 days, the order will expire. So this is what you as advocacy or somebody, you need to have a conversation with your client and decide who's going to be paying attention to this, but someone needs to be paying attention to make sure that service happens within 14 days, because if it does not, the order will expire. And then if before those 14 days run, the petitioner will need to file a service by alternative means if there's concern that it's not going to get served within those 14 days. So really important that somebody is paying attention, especially if a hearing isn't scheduled. Because if a hearing's scheduled, then you're going to be in court and you can deal with it at that point. But if there's no hearing scheduled, somebody's got to be paying attention to make sure that that order got served and it doesn't expire. If the ex parte order is issued and if there's additional relief or the petitioner asks for a hearing, then a hearing has to be scheduled within 7 days of the ex parte being issued. So lots of different timelines for service. And so really important. I know that it's hard because I will get confused and I'll have to pull up this slide and look at it because I'll get confused myself. And remembering, is it 14? Is it 7? Is it 10? But really important to remember these timelines for service, because it, especially that expiring after 14 days, because you want to make sure that your client is aware of what could happen. Okay. So that's kind of our setup, our real basic information about orders for protection. Are there any questions, Tracy, before I move on to HROs?
There's one question about how this might look in Dakota County. I'm not sure if you can answer that specifically.
My understanding in Dakota County is it runs the way that I just explained. I don't think they do anything different, but courts create new things that I don't always know about. So yes, as far as I know, you present it to court administration gives it to the judge, and then from the judge it goes to, if it's signed, to law enforcement, probably back to court administration, who gives it to law enforcement to get it served. But I don't know of it operating differently in Dakota.
Okay, thank you.
Yeah. All right. Harassment restraining orders. So our definition of harassment has grown over the last number of years. Important to pay attention to the additional things that have been added to our harassment statute. So harassment in Minnesota includes a single incident of physical or sexual assault. I will note that it says sexual assault. Under Minnesota criminal statutes, we call it criminal sexual conduct, so CSC. This does not use that language. It says sexual assault. So I don't know what the definition of that is, but I would argue it's broader than the CSC statute. The second is repeated incidences, which the court has found to mean 2 or more of intrusive or unwanted acts, words, or gestures that have a substantial adverse effect or are intended to have a substantial adverse effect on the safety, security, or privacy of another. The third one is a single incident of non-consensual dissemination of private sexual images, otherwise known as revenge porn. We don't really like that term, but folks know what that means. So we call it non-consensual dissemination of private sexual images, but some folks call it revenge porn. A single incident of using another's personal information without consent to invite, encourage, or solicit a third party to engage in a sexual act with the person. I often refer to this as Jenny's Law. Some folks may remember the Tommy Two-Tone song, 8675309. Yeah, so putting somebody's phone number on a bathroom wall and saying for a good time call, that's illegal in the state of Minnesota now. Don't do that. And if you do it, you could end up with a harassment restraining order in addition. So, but this is really more getting at, I mean, that would be harassment under this definition. It also is looking at things like people who post on Craigslist and say, you know, Jane Doe really likes rough sex, go over to her house, here's her address, right? It's also doing stuff like that. The fifth example is targeted residential picketing. And then the sixth is a pattern of attending public events after being notified that the actors present at the event is harassing to another. So we have now 6 possibilities of behavior that could be considered harassment in the state of Minnesota. So by who to who? By anyone to anyone. Statute says regardless of the relationship between the actor and the intended target. So there is no relationship requirement to be able to get a harassment restraining order. One just needs to show that the respondent engaged in harassing behavior as defined under the statute. I once had somebody who wanted to get an order against the entire town. I told them that that might be a problem because then law enforcement would be unable to enforce the order because they wouldn't be able to talk to you without violating the harassment restraining order. Sometimes you got to think of different options, which is what we did in that circumstance. But remembering that it is to who and by anyone. So there's no relationship requirement, which this can be very, very useful to non-intimate partner sexual assault victims, which is where we often see our folks using it.
Raina, we got another question in.
Yeah.
So a mom has filed a harassment restraining order on behalf of her 17-year-old child, but the next day the child turns 18. The father in the case is the respondent and is requesting a hearing.
I think that this is a little too specific for the broader. So please give us a call. We're happy to talk to you about this circumstance, but that's a little too narrow and specific, I think, for these circumstances for the webinar. But please give us a call. We'll talk to you about it for sure.
Sounds good. Thank you.
Thanks, Tracy. Okay, so the relief available under harassment restraining order is super duper narrow. All right. So the OFP statute is really broad. We've got like 22 different types of relief, including an other category. The harassment restraining order statute is very, very narrow. You got 2 options, and there is no other category. It is to cease or avoid harassment of the other person or to have no contact. Those are your options for the relief that is available. We do have some unpublished case law that says a radius around a person's home can fall under that definition of no contact. But the relief that is available here is very narrow. It doesn't include any child-related relief. You can't get parenting time, can't do custody. There's no restitution. There's no pet protection. It's very, very narrow. No harassment, no contact. All right. So, and there is no other category in the harassment and restraining order statute. So, narrow relief. Who can file in this? Can you file in the state of Minnesota? The statute says that the petitioner can file either where the petitioner or the respondent reside. Again, it's that individual's desire to make a permanent home, or where the harassment occurred. All right, so those are the two counties that a petitioner could file in. Who can file for a harassment restraining order? An adult victim of harassment, right? Adults can always file on their own behalf. And then the statute here is different than the OFP statute. And it says that if the person is a minor, either their parent, guardian, or step-parent can file on the minor's behalf. Those are the only three types of people who can file on behalf of a minor: parent, guardian, or step-parent. We actually have a variety of case law on this piece, and the court consistently goes back to the statute and says the statute is very clear: parent, guardian, or step-parent. And we're talking like a legal guardian in this case, so somebody who has some sort of legal guardianship. Again, types of harassment restraining orders, similar to the order for protection. You can get an ex parte harassment restraining order. Again, by one party without notice to another party. You got to allege that immediate and present danger of harassment, because this is extraordinary relief. And in Minnesota, ex parte harassment restraining orders become final without a hearing if neither the respondent nor the petitioner request a hearing. And we'll talk about timelines in a moment, but know that if nobody asks for a hearing, it will become final. If somebody asks for a hearing, you get a final ex parte order, either after an agreement or after an evidentiary hearing. What does a petitioner file? They file that petition and affidavit for ex parte relief, and they file the law enforcement information sheet. And so they take that paperwork, and in every other county but Hennepin, they present it to court administration, and it's given to the judge. And then if it's signed, then from the judge, it goes back to court admin, who give it to law enforcement for service. If we're in Hennepin, if it's a community-based advocate, they will present it to the signing judge of the day. And then if it is signed, then it's passed to law enforcement for service. If they're doing it without a community-based advocate, they'll go through the self-help center in Hennepin County, and the self-help center will then take care of shepherding the HRO through the process, getting it to the judge, and then if it's signed, getting it out to law enforcement for service. For court fees. So harassment restraining orders are a little more complicated as it relates to the court fees. So it's about-ish $327 to file a harassment restraining order. It will vary a little bit depending on your county, because some counties have different additional fees that are tacked on or whatever. So, but around that. However, per our statute, the fee is waived if the petition alleges a violation of 609.749 subdivisions 2, 3, 4, or 5, which is the stalking statute, and then aggravated stalking or a pattern of stalking conduct, or if it violates 609.342 to 609.3451, which is the criminal sexual conduct statute, 1st through the 5th degrees. So for the vast majority of the folks that we would be working with, they should qualify for fee waiver because the petition should be alleging a violation of either the stalking statute or the crim sex statutes. Do remember this was just modified a couple years ago. It includes the respondent. So petitioner and the respondent both can get those fees waived. If the petitioner's petition alleges stalking or criminal sexual conduct. So those fees should be waived. If for some reason the petition does not allege one of those things, then the petitioner can file for informa pauperis or fee waiver, depending on their financial situation. So you'd have to follow that process. How long does a harassment restraining order last? Up to 2 years. The statute does allow for the court to issue ones for a shorter period of time, but the statute does not allow an option for making it longer than 2 years. So they can get a 2-year or harassment restraining order. It can be less, but it can't be more. And then there are 50-year harassment restraining orders, and towards the end of the presentation, we'll talk more about 50-year orders and the requirements under statute, what that looks like. Timelines for service. Harassment restraining orders have no specific timeline for service. Okay, so they don't have, like, unlike orders for protection that have to be served within 14 days or they expire, there is no specific timeline for service in a harassment restraining order. It could get served, you could file and it gets served the next day, or it doesn't get served for 3 months or 8 months. There's no timeline on when service has to happen. However, the harassment restraining order is not enforceable until it is served. So it is valid, it doesn't expire, but it's not enforceable, can't violate the order until it is served, okay? So that's important to note. Once it is served, a hearing must be requested by the respondent within 20 days of service. Okay, and this is a change. We fixed this about 2 years ago. Some folks might remember we had some conflicting language for a while that said 20 days after service or 45 days after issuance, and then even farther back it was all 45 days after issuance. So this is a change within the last 2 legislative sessions, and it is 20 days after service. All right, so that's really important to note. All right, so differences between orders for protection and harassment restraining orders. Orders for protection, they are a family court. They talk about domestic abuse. Got to have that special relationship of a family or household member, and the relief is super broad. It can include property, custody, exclusion from housework or daycare. Very broad relief. Harassment restraining orders are a civil order. And the reason this matters is it means orders for protection use the rules of family court, which for most of you as advocacy may not specifically matter for you, but it does matter it could potentially matter sometimes. There are some weird, quirky things about OFPs that it is because the rules of family court apply. Harassment restraining orders, because they are civil orders and they come out of civil court, they use the rules of civil procedure. HROs, there's no special relationship that is necessary. Got to show that harassment occurred, and the relief is super narrow. Only no harassment and no contact. All right, Tracy, are there any questions before we move on to talking about writing the affidavit?
Nope, no other questions.
Great, thank you.
Yeah, you're welcome.
All right, so let's talk about writing the affidavit. So what's really important is that you prepare an affidavit to meet the standard the court is going to apply. All right. So that's the most important thing, and that when you're helping somebody as an advocate and you're helping them file for an order for protection or a harassment restraining order, that you're helping them think through what is the standard and what do I need to be. How do I work with my facts and have them meet the standard? How am I saying all the things that have occurred? Because this isn't about massaging facts. That's not what I'm saying. I'm saying, like, there's a lot of stuff that happens in these relationships, and how do we make sure that all that needs to get out gets out, and that stuff that doesn't necessarily need to doesn't if it's not safe. So when we're looking at so the first time somebody is getting an order for protection or a harassment restraining order, you got to show that domestic abuse or harassment occurred against the petitioner, right? And this is true even if that order is being issued on behalf of a child. Okay, so if that person, if their name is up in the caption as a petitioner, they have to have experienced domestic abuse if it's an order for protection, or harassment restraining order or harassment if it's a harassment restraining order. So If you want to put a child, if you want to get an order of protection on behalf of a child, you have to show they've experienced domestic abuse. And then you also need to figure out who's going to testify to that domestic abuse. I get asked, is witnessing domestic abuse, does that create fear of imminent physical harm? I think it's possible, but your question really is going to be, how are you going to prove it? And so that is always a huge piece of, I can sit and talk theory with you all day long about how absolutely, I think theoretically, I think I've worked with clients where their kids are definitely, they are experiencing emotional concern and they're scared and they have every reason to be, but how are you going to prove it? And you got to remember that the law, that's what that's about, is you got to be able to prove it. So always true, even if it's on behalf of a child. If you're not going to be able to necessarily prove the domestic abuse or the harassment against the child under the order for protection, then look at child-related relief. Then you can look at custody, you can look at parenting time changes. The court is allowed to consider the safety of the petitioner and the safety of the child when considering those things. And that can consider things that don't rise to domestic abuse. Okay. So keep that in mind. Thinking about on the harassment side, right? If you're trying to prove harassment because of multiple incidences, you got to show a couple of different things, right? You need to show that there has been multiple incidences that interfered with somebody's safety, security, or privacy. So you got to not only show the incidences, but you also have to show it's affected that person's safety, security, and privacy. And so how is the petitioner going to get that information in the affidavit? All right, so you got to show that domestic abuse or harassment occurred. An overt act is not necessarily necessary. Good job, Brenda. Is not necessary. Need to show totality. The court should be looking at totality of the circumstances, including a history of past abusive behavior. And I need to cough here for a second, so hold on while I do this. Okay, hopefully I did mute my my headset, so you guys didn't have to hear that. All right, so you got to show that domestic abuse or harassment occurred. You got to show it occurred against the petitioner by a family or household member if it's domestic abuse, or by anybody if it's harassment. All right, you're writing the affidavit. You're helping the petitioner write the affidavit. Things that are helpful: dates that the incidences happen. If a specific date is not available, including the month or the season or the year, right? And so often when you're talking with petitioners or clients, when you're writing an affidavit, you're thinking of what's the most recent incident and what's the most serious incident. And so that's where the most serious incident may have a harder time potentially coming to what was the specific date. But month, season, year, sometimes it may be really helpful to say, over the last 5 years, X has happened 10 times. So trying to figure out how to get that as that information in. So dates the incidents happened, where the abuse occurred, the abuse or the harassment occurred. Did it happen in the living room? Did it happen at the bus stop? Like, where did this occur? What part of the body was there a part of the body that the abuser or the harasser touched? They grabbed my arm, the harasser, touched my bottom. What happened? Was there any part of the body that was touched? If it was touched, what did the abuser use to do that, to harm? Was it with a hand or a fist or a foot? If there were any threats that were made, using the exact words, if possible, if they remember. If they don't, then don't use exact words. And placing those words in quotes if it's remembered exactly. I am also a big fan of, this kind of sounds weird, but swear words and derogatory things. And part of the reason is, and I've talked to a number of judicial officers, so it depends on how each court handles it, but I know that there are some judicial officers who are reading ex parte affidavits as they're kind of doing other things. and coming across a swear word, just our nature, we stop, right? You stop and you pay attention. And so sometimes if the client is comfortable, and I've absolutely worked with clients who are like, I'm not comfortable putting that in a court document, that's okay too. So this is all within the comfort level of your client. But it can be helpful if a judge is going real quickly and they're scanning, all of a sudden they see a swear word or a derogatory word, it can often make them stop and have to pay better attention to what they're reading, which can also often be a good thing. So threats were made, exact words if possible, and only if it is remembered. If they don't remember, then don't use exact words and don't place them in quotes. Describing the gesture, it was a fist raise, was the face flush? You're trying to paint a picture for the court. Remember, this is just words on a paper that that a judicial officer is reading, and you're trying to help the client paint a picture, trying to help the judge understand why this was so scary, so harmful, so whatever, right? So you're trying to meet why this affected their safety, or it affected their privacy, helping the court understand why. State how the petitioner felt, including if they were afraid, right? I tell petitioners when we're looking at on the order for protection side, we really want to be able to articulate fear. Are you afraid? And what? And why are you afraid? For a harassment restraining order, did it affect your safety, security, and privacy? And how did that happen? How did it affect those things, right? So making sure that that gets into the affidavit. And again, what are they specifically afraid of, or what specifically affected their safety, security, or privacy, or what did they do about it, especially when we're talking about safety, security, or privacy? What did they do did they take personal safety classes because they were so afraid, right? So showing the court they used to not lock their doors, they lock their doors all the time now, or they always make sure their cell phone is very close so that they need to call 911. Like, folks are doing things to help keep themselves safe or help them feel safer. What are those things? So if somebody was afraid that they would be hit or kicked or prevented from leaving, explaining that to the court. If somebody was yelling, how loud they were. And did it hurt their ears? Did it make their face red? Or was what was so creepy is how very calm the voice was, but the angry words that were coming out of their mouth and why that made them afraid. How long did the incident last? And was there anybody else who was present during those incidences? So letting the court know if there was anybody else present. So I got a couple examples. So I have like an example that's probably not the best, and then an example of something that would be better. So respondent has called my house and is saying that he is going to make me sorry for making him pay child support. I'm afraid of what he's going to do. All right, that's probably not the strongest OFP application. I think in most of our counties, we're going to have a hard time getting that one signed, because the court's going to be like, well, he can say he's, mad that you're making him pay child support, and I don't know what you're afraid of. What you're afraid he's going to take you to court and he won't have to pay, or he'll have to pay less, or like, I don't know what you're afraid of, right? So a better example for an order for protection would be on May 14th, 2018, the respondent called my house for the third time in a week and was very angry. He was yelling at me and he told me I was going to be sorry. He also said that he was not going to pay any effing child support. The respondent also told me to back off. I am concerned for my safety because when I lived with the respondent back in 2007, he threw plates at me, kicked our dog, raised his fist at me when he was angry. The respondent has also told me he would fine me and hurt me if I ever sought child support from him. I am now afraid that he will make good on his threats to harm me. All right, so you can see we've got specific dates. We have specific things that the respondent was saying. We know how many times the respondent has now called. We know the respondent was yelling. We got some swearing in there. We understand why this is so scary for the petitioner because he has threatened her in the past by saying that he would hurt her if she ever sought child support. And that we also know in the past that he's, done things that are scary, like throwing plates and kicking dogs and raising fists. So in only a couple of more sentences, because it's really not that much more, we get a much better understanding on why this petitioner is afraid of this respondent. And that's very helpful. In addition, we also get a better idea of the family or household relationship because we got the stuff that says that they live together. We assume that there's a child involved here, but we don't know for sure. But because of the child support piece. But so all of these things make it much clearer for the court. And that ex parte is probably going to get signed in almost all of our counties because it's clear to the court why the petitioner is afraid, what they're afraid of, justifies their fear, and that their fear of imminent physical harm and why their fear of imminent physical harm is reasonable, and why it's imminent. So it covers all the bases. Here's a harassment restraining order example. Inconsistently follows me and drives constantly down my street, parks on the opposite side of the street, and or drives through development May 17th through, or April 17th to May 4th. All right, I'm not sure what's going on here. This is, again, one of those that I'm not really sure would ever get signed. You might be able to, you got a good judge. You might be like, all right, well, I got something that kind of looks like following going on, but I'm not really sure. So here's an example that is a stronger off of the same facts. So since April 17th to May 4th, the respondent has been driving past my house about 5 times a week, or has driven past my house about 5 times a week. I live in a housing development and the respondent does not have a reason to be in my neighborhood. About twice a week, the respondent will park across my street from my house and stay there for about an hour and then leave. In this time period, respondent has followed me when I was in my car 3 separate times. He followed me from my work all the way to my home. And when I pull into my driveway, the respondent then speeds away. This behavior is scaring me, and I want the respondent to leave me alone. All right, so we have a better idea with an only additional couple sentences, but we have a better idea on the behavior that's going on, this kind of stalking behavior that is happening, of the following, of the monitoring that's going on. And then in addition, in this last sentence, we have a statement about how it's affecting their safety, security, or privacy, right? So in this case, it's safety because it's scaring them. And they want to be left alone. So this really helps the court say, all right, I'm seeing multiple incidences of harassing behavior, and I see it that it is affecting their safety, security, and privacy, right? So they need to be able to show both things. And then when you're requesting relief, be thoughtful and work with your client on thinking about what kind of relief you're going to request. And sometimes there's a really strong thought of that needs to go into, do I apply for an order for protection, or do I apply, or does the client needs to think carefully about, does an order for protection make more sense for them, or does a harassment restraining order make more sense for them? And there are different reasons to look at different, sometimes, you don't need all the relief of an order for protection, when really the relief of a harassment restraining order makes more sense. And so there are a variety of strategy reasons to think through, and then also being very thoughtful about what relief one is requesting, and what does that mean. And so having very thoughtful conversations and helping your client figure out what makes the most sense for them. And again, if the client wants to ask for supervised parenting time or supervised exchanges, again, how is that going to happen? And make sure to have a plan. That's the best way to get the court to accept your plan over no plan. So,
Raina, we have a participant who's asking if they should not type out curse words and instead type it like your example.
I would go with the comfort level of the client. I think you absolutely could type out the curse word. I don't know, I'm doing it because we're throwing this up on the internet, and I don't know. sometimes my PC-ness, I'm not always sure, but I think that I think you go with whatever is comfortable for your client. And if the client is comfortable with using the full word, I'd use the full word because again, you're more likely to get that judicial officer to stop and to read, which is what we really want to happen, right?
Thank you.
You're welcome. Any other questions?
No, none that have come through so far.
Great. All right, so we're gonna move on. We're gonna talk about court process and how this happens. So this varies from when you get to a hearing, the court is normally going to make the respondent give the respondent three options. The respondent can admit to the abuse or the harassment and agree to the issuance of the order, and the court will make findings. So if the respondent says, oh yeah, I did that, everything that's in that petition, I did it, I agree to the issuance of the order, the court would make findings that whatever was in the petition, they would make findings about the petition and that domestic abuse or harassment occurred. And then it will issue the order for protection or the harassment restraining order. This almost never happens. I've had it happen once. I've only seen this happen once in my 15 years. So it does happen, but it don't happen very often. So just, you know. The respondent can neither admit nor deny the abuse or the harassment, but agree anyway that the order will issue, but without any findings. So the court isn't going to make a finding or specifically state that any incident of domestic abuse or harassment occurred, but the respondent is agreeing to the issuance of the order. And so the order will issue and the petitioner gets their relief that they are looking for, that they asked for in their order. That happens a lot. I see that very regularly, often, especially, or if there are attorneys involved, there's a negotiated agreement that normally leads to an order without findings. So that does happen a fair amount. And then the third option is the respondent can deny the abuse or harassment that's in the petition and ask for a hearing. In Hennepin County, that might lead to mediation for a harassment restraining order first. If they ask for a hearing before an actual evidentiary hearing will happen. Each county, if the respondent asks for a hearing, handles this differently. Some counties, it will be the hearing happens right away. And like Anoka County, almost always you're going to have your evidentiary hearing like that day, if not right then, but for sure that day, almost always that day. Ramsey County handles it differently, where if the respondent asks for a hearing, the evidentiary hearing is scheduled for a later date, most of the time. There is it's no hard and fast. Always be prepared. Always prepare your client to potentially go forward that day and be prepared to potentially have a hearing another day. It's just the way that court is. But it's really important that you find out how it works in your county. There are 87 of them, and so I don't know every single county and how they handle it. So it's really important for you to figure out and find out how is it normally handled in your county, so that when you're working with a client, with a victim, you can help them prepare and know going forward what might happen. And definitely, I do see this 3-option thing happen in most counties, has been my experience. So you can also talk to them about, okay, we're going to go into the hearing, and the judge is going to offer these 3 options, and and talk through that piece of it. If the respondent asks for an evidentiary hearing, normally the process looks like this. Especially if there aren't attorneys involved, the process will look like this. You have a petitioner your client, most often your client is going to testify first. It's really important to prepare the person that you're working with, that the respondent will have the opportunity to cross-examine the petitioner. Again, how this happens in every county, or even it varies from judicial officer to judicial officer. Some judicial officers will really direct everybody's testimony when there aren't attorneys involved. Sometimes the judges will let let the petitioner just testify how the petitioner wants to testify, and will let the respondent do cross-examination of the petitioner, and will only intervene if the court is asked to intervene. And when I mean asked to intervene, like asked because somebody says, Your Honor, do I have to answer that question? Kind of intervening, not like, hey, will you help coordinate this situation? And this just varies. And so that's a learning of how your judicial officers are going to handle order of protection, harassment, restraining order hearings when there aren't judges or when there aren't attorneys involved. So petitioner testifies, respondent cross-examines. When I'm preparing my clients for cross-examination, I always remind them that there are just some real basic things to always remember. If you don't know the answer, it's okay to say you don't know, and preferably just say you don't know. Don't try to guess. Don't try to make it up. Don't try to assume. Just say you don't know, and that's okay. If you don't understand the question, then say that. Don't try to guess, don't try to assume, don't try to make the answer fit. If you don't understand the question, say, I'm sorry, I don't understand the question. Can you restate it? Don't try to force anything. Forcing things is where stuff gets crazy. So never try to force, and just answer the question. And if the question is asked weird, but that's the question you understand it to be, then answer the question. And just just answer the question that's asked. Then the petitioner is able to put on any witnesses that they may have, and then the respondent can cross-examine those witnesses. After all of that happens, after all the witnesses are done and all the petitioner is done testifying and cross is done, then the respondent will have an opportunity to testify. The petitioner will then have an opportunity to cross-examine. And when I'm working with folks, I tell them that I very rarely cross-examine a respondent. You are not going to have a Perry Mason moment, or, that's so old. Elle Woods is probably even so old now too, but you're not going to have those moments where you're going to get the respondent to just like break down and start crying and be like, you're right, I'm a horrible person. It's not going to happen. So why give the respondent more opportunities to bolster their story and to lie more? So unless I got something that I can prove, I very rarely cross-examine the respondent. And you're probably going to make the judge really happy, because the judge knows these things too, and it's just it's not helpful testimony, and it's just kind of frustrating, and everybody gets out of there a little bit earlier. So unless you got something you could really prove, I tend to not cross-examine, because it's just not going to get you anywhere. Then the respondent gets to put their witnesses on, and then the petitioner gets to cross those witnesses. So when the petitioner is thinking about their testimony, and you as advocacy are helping them get ready for their testimony, things to think about, again, and it's very similar to writing of the affidavit. So if the petitioner was physically harmed, describe the most recent incident. What was the date, the approximate time? Describe the assault itself or the threatening behavior. Try not to, talking with your client about not dwelling on the events that led up to the assault, unless for some reason it's very, very important. Remembering that judges are often busy, and so they don't always have the greatest attention span. So getting right to it is very helpful. And so try not to dwell on those events leading up to it. Use specific terminology. Be specific. Don't use conclusions. And being as specific as possible. Stating the estimated number of times that the petitioner was kicked, slapped, pushed. Being as concrete as possible is very helpful to the court. If there were any children that were hurt or threatened in any way, state how that was, especially if one is looking for an order on behalf of a child. So being clear about that. It's important for the petitioner to also describe the results of the assault. Were there cuts, bruises, sprains, headaches, internal injuries? Like, what happened? How were they physically harmed? Were they treated for any of those injuries? Where, by whom, when did that happen? What treatment was provided? Did the petitioner take any photographs? And we have a different webinar series or different webinar on evidence and having a conversation about being able to get evidence in. So I'm not going to go into that here. So please feel free to listen to that webinar. That will be helpful in that circumstance. Did anybody witness it? Either the injuries, what about the treatment? So was there a conversation with the petitioner's mom right afterwards, and mom came over and saw the black eye, and mom saw the house all turned over, and mom, so were there any other witnesses? Were the police called? Did they file a report? Was the respondent arrested? Were any criminal charges filed? Did the petitioner leave the home? If they did, where did that person go? Did they go to their moms? Did they go to their best friend? Where did they go? Did they go to a hotel? Was there any loss that happened either by job or property because of the assault or as a result of the assault? So describing the results of that assault. What the court is looking for is, very almost always, especially when we're talking about domestic abuse or if we're talking about under the harassment statute, this is all quote unquote, he said, she said. Yeah, of course it is, right? These things happen. Domestic abuse happens within the confines of our private home most of the time. So of course it is. So the court is trying to determine who is more credible. And courts figure credibility from a variety of things, but one of them is detail. And how detailed can somebody be, and how consistent then is their detail? So a consistent, detailed story is often seen as more credible than a vague or inconsistent story. And so making sure that the client is able to provide as much detail as they are comfortable in providing, because I also recognize that there may be details that are very uncomfortable or scary or dangerous for the petitioner to disclose, but having a thought process about how much detail can possibly go in there is always very helpful. If the petitioner is testifying when we're looking at fear of imminent physical harm. So being clear, what specific actions cause the victim to feel fear? What is it that the abuser said or did? And when did this occur? The date and the time. Describe the abuser's demeanor. Flushed face, angry tone of voice, were they shouting? And then not only what was the action that caused the petitioner to feel fear, but why? And what are they afraid the petitioner or the respondent is going to do, and why? That is really, really, really important when we're talking about fear of imminent harm. I'm just afraid, I'm not sure what they're going to do. Well, what do you mean when you say that? Well, I'm just not sure. Well, but what do you mean? Right? Because the court is really looking, especially on orders for protection, they're thinking about safety. And so needing to get to that, I'm afraid they're going to file a divorce. Well, that's a legit fear and something to be concerned about, but that's not what an order for protection is here to protect you around. It's meant to protect your safety. And so that's what the court is looking for. So being able to articulate what they're afraid the abuser is going to do and why. Again, think back to our good example of the order for protection affidavit. I am afraid that the abuser is going to hurt me because a year ago, the abuser told me if I ever filed for child support that they would hurt me. Okay, so it's connecting the why. Harassment. So if the petitioner is filing a harassment restraining order, again, dates and times of the incidences that happened, how many times a day, a week, a month does this behavior happen, state where it happened, if threats were made, again, using the exact words, describing what the gestures were, and again, stating how the petitioner felt and being thoughtful about that substantial adverse effect and that it's having an effect on their safety, security, or privacy, and be specific. I don't mean that I want petitioners to get on the stand and to say, and this is affecting my safety, security, or privacy, because the court then is going to think that the petitioner is coached, even, whether they have a lawyer or not. But the petitioner should be articulating how it is, making sure that they're clear and articulating something about how it's affecting their safety, security, or privacy. Stating how loud the harasser's voice was, for how long the incident lasted, or if there was anybody else who was present. So making sure to get all that testimony in. Do we have any questions, Tracy?
No questions at this time.
Great, thank you.
You're welcome.
All right, so you had the protection order hearing, got the protective order, and now what? All right, so what are the things after the hearing? So the first thing that I do want to encourage advocacy to do is to file something called, or actually advocacy doesn't do it, encourage the person you're working with, the petitioner, to encourage them to file something called a notice of entry of order. There are, under the handouts, there are two handouts, well, there's actually three handouts there. One is of this PowerPoint. Two is a detailed list of things to do to file the notice of entry of order. And then the third is a Word document that is actually a example of a notice of entry of order that y'all can use. Why is this important? A notice of entry of order is, it starts the appellate time clock running. And if you do not file it, it means the respondent could appeal for essentially ever. And we actually had this happen in a case called Petrovnik, where Ms. Petrovnik had gotten a order for protection. She had actually had it extended 2 more times, and then Mr. Petrovnik, after about, I think it was 4 years, because the initial order was a 1-year order. This is a number of years ago, and then we had another 1-year order, and then we had a 2-year order. After 4 years, Mr. Petrovnik moved to appeal the initial first order for protection, and since there was never a notice of entry of order, he was still allowed to appeal that order. So it starts the time clock running. Do you do it in a case where your client doesn't win? No, because it doesn't, there's, the only person who would ever be appealing potentially would be your client. So there's no reason to do it there. You may have a respondent that's if everybody agrees and you get an order that everybody agrees to, you probably don't need to do it there, although it depends. But if you went to hearing, and especially if you have a highly litigious respondent, you probably want to help your client figuring out how to do a notice of entry of order, because it starts that appellate time clock running, which is then 60 days. They have 60 days from the date of the notice of entry of the order to file for an appeal. So I really encourage folks to think about it. You got more questions, please feel free to give us a call. We'll talk you through it. But definitely on the highly litigious respondents, this is something you really want to think about, because you want to get that time clock running. All right, so we got the notice of entry of order. So your client's going along, the protective order is working, and now the order's coming up on a time that it's either going to expire, or the order has already expired because of a variety of reasons, and now they want to get a new order. So this is on extending. So for extending or getting a subsequent order for protection, the statute talks about how the respondent has violated a prior or existing order for protection, or the petitioner is in reasonable fear of physical harm from the respondent, or the respondent has engaged in acts of harassment or stalking, or the respondent has been incarcerated and is about to be released, or has been recently released from incarceration. So the standard for getting an extended or a subsequent order for protection against the same respondent is a lower standard than getting the initial protection order. You need to show one of these 4 things. And I will note that the second is reasonable fear of physical harm. There isn't that imminent standard. So it's a much lower standard. And while my slide here says you must have a hearing, actually the statute was modified about 2 legislative sessions ago. And if somebody if somebody is only asking for the relief, remember we talked about the relief for the initial order back about over an hour ago, and we had the 3 slides. If they're only asking for that limited relief that's on those first 2 slides, they actually now do not have to have a hearing unless the respondent requests it. If they're asking for that expanded relief of child support or modification of a parenting time schedule or any of that expanded relief, then they do need to have a hearing. But if they're only asking for that limited relief, they don't have to have a hearing unless the respondent requests it. And then we follow the same timelines of the respondent has 5 days from the date of service to ask for a hearing, and the court has to schedule a hearing within 10 days. So that's been a change in our statute within the last couple of years. Extending or a subsequent HRO. There is no statutory ability to extend a harassment restraining order. It doesn't exist in our statute. There's no language that is there. It says it is silent. So therefore, since it is silent, I argue you can't do it. You have to have new and recent incidences of harassment. Because you'd have to be applying for a new harassment restraining order. You're under the same standard. There's no ability to extend or to have a subsequent harassment restraining order. I've had to have this conversation with lots of people, including judicial officers, when I was in front of them, reminding them that you can't just extend a harassment restraining order. So no statutory ability to do that at this point. 50-year orders. Remember I said I would talk about 50-year orders? This is where I'm going to do that. Both the harassment restraining order and the order for protection statute have this ability to apply for a 50-year order, harassment restraining order or order for protection if the respondent has violated a prior or existing order on 2 or more occasions, or the petitioner has had 2 or more orders in effect against the same respondent. There's allegedly supposed to only be this limited relief of no acts of domestic abuse or harassment, depending on what type of order, and no contact. But I've seen broader ones, and I don't have any case law around it, so I don't know how the court would feel about it. But there is this option for a 50-year order if the respondent has violated, and violation does not mean criminal conviction. It doesn't even mean that somebody has been arrested. We're over here in civil court land, and so it means, can you show by a preponderance of the evidence that the respondent has violated the order? So we're under a much lower standard here. We have case law that says this. So violated the order on 2 or more occasions, or the petitioners had 2 or more orders against the same respondent, and somebody can get a 50-year order for protection. Modifying. If somebody would like to modify, they need to file a motion with an affidavit, and the statute does require a hearing, and you can find modification forms on the court forms website. Dismissal. We have no, so I have down here, it says process varies from county to county, and that's because we have no statutory language about dismissing. And so generally what we know as just in how civil court works is that a petitioner can arguably always dismiss any action that they file, and that's what they would be doing here. Some counties you file a motion with an affidavit. Some counties, I've heard it's a letter. Some counties make you go through a variety of hoops. Some counties don't. It is so vary from county to county. And so you really need to talk with, learn how it works in your county. And even from then, learn how it works for your individual judicial officer as it relates to the petitioner dismissing a protective order. On the respondent side, there is no statutory basis for the respondent to move to dismiss a protective order, either an OFP or an HRO, except for a 50-year order. And then there is a specific process, but it is only for 50-year orders that are issued under the 50-year order part of the statute. Otherwise, there's no statutory basis. So the respondent really can't move to dismiss. There's a bunch of legal reasons behind that I won't bore everybody with, but there's really no statutory basis from it. All right, and looks like I have like 1 minute to talk about DANCOs. So we're going to do that. Domestic abuse, no contact orders. They are issued in criminal cases where there is domestic abuse, as defined under 518B.01 subdivision 2. In cases where there is stalking, as defined under 609.749 against a family or household member, as defined under 518B. It's issued when there is a violation of an order for protection, or it is issued in a violation of a DANCO. I love that you can get a DANCO for violating a DANCO. Like, that's the most amazing thing to me ever. And we actually have Supreme Court case as it relates to this, where we had Mr. Ness with multiple DANCOs because he kept violating and they kept issuing new ones. So they're issued in these cases. These are criminal cases. And they can be issued either pre-trial, before there's any sort of conviction, or as long as the criminal case is still pending. So it can be issued pre-trial, and or they can also be issued post-conviction. So after the defendant has taken a plea, it can be part of sentencing. A part of the sentencing process, but it is we have pretrial DANCOs and post-conviction DANCOs. They are not a condition of release, which is specific around that you can't bond out, you can't take bail at a higher rate and get out of them. And they have to be issued in the language talks about a separate proceeding immediately following any pretrial release or sentencing. The way that's handled in most courts is the judge just says we're moving to the DANCO phase of the pretrial, and then the court goes on to decide about issuing the DANCO. So that's how normally that is handled. All right, so that's the real quick and dirty about a DANCO. Real quickly, differences between OFPs, HROs, and DANCOs. For you guys. And number 6 is falling off the edge. I apologize. So orders for protection, they're issued under 518B.01. They are a family court order, and you got to allege 5 things: physical harm, infliction of fear of imminent physical harm, terroristic threats, criminal sexual conduct, or interference with an emergency call. Harassment restraining orders, they are issued under 609.748. They are civil orders. You have to allege one of 6 things: a single incident of physical or sexual assault, repeated incidences of intrusive or unwanted acts, words, or gestures that have a substantial adverse effect or intended to have a substantial adverse effect on the safety, security, or privacy of another, a single incident of non-consensual dissemination of private sexual images, a single incident of using another's personal information without consent to invite, encourage, or solicit a third party to engage in a sex act with the person. 5 is targeted residential picketing, or 6 is a pattern of attending public events after your presence has been made to know that it's harassing to another. Domestic abuse no contact order, or DANCOs, they're issued under 629.75. They are criminal orders. They are issued in criminal cases where criminal charges are either pending or where there's been a conviction for domestic abuse, harassment or stalking when committed against a family or household member, violation of an order of protection, or violation of a prior domestic abuse no contact order. Under an order for protection, you got to have a specific relationship, which is a family or household member as it is defined. Harassment restraining orders, no special relationship necessary. You can get one against anybody you want, as long as they've committed harassment against you. And the domestic abuse no contact order requires a family or household relationship. The relief is very broad in an OFP. You can get all sorts of things. Harassment restraining order, the relief is super narrow. No contact, no harassment. The relief is very narrow in a domestic abuse no contact order also. Only no contact. And finally, orders for protection. There is no fee for a petitioner or the respondent. Only a victim or the petitioner can seek an order for protection. There are very strict timelines for hearings under the order for protection statute. And things to remember, that even if the OFP is dismissed, there still could be a domestic abuse no contact order. Under the HRO, there are no fees for the petitioner or the respondent if the petition alleges a violation of the stalking statute or of the crim sex statutes. Only a petitioner can seek that order. There are no timelines for hearings except for the 20 days after service. And there, even if the HRO is dismissed, there still could be a DANCO or some other criminal no contact order. For the DANCO, there's no fee for anybody. The prosecutor is who seeks that order. It has to happen in a proceeding in which pretrial release or sentencing issues are decided at. And even if the DANCO is dismissed, there still could be an OFP or an HRO in place. And also just the reminder, the family court cannot modify a criminal court's order. And so those things are important to remember. And finally, there's the information about me and the information about Standpoint. Sorry, the end got a little whirlwindy. So please reach out to us for whatever questions that you have. We are always here to support you, to help you think through things, to help you figure out strategy. That's what we exist here for. So please, please use us. You are never, ever bothering us. We love to talk to you, I promise. So please call us and use us as your resource. Tracy, is there anything else that we need to do before we close up here?
Yeah, we had two quick questions come in. One is, can a victim in a criminal case start a proceeding to dismiss a DANCO?
There's no proceeding to start, and it varies from county to county and city to city, how that is handled. Sometimes that happens through prosecution. Sometimes it happens through victim witness. Sometimes it happens through the defense. There's no clear process. So it's kind of learning how it works in your community.
Great, thank you. And then the next question, the last question that we had, is there a waiting period from when a petitioner dismisses an order from the time that they can file a new order? So let's say they dismiss the order and then they want to file a new order. Do they have to have a waiting period in between that?
As long as there's a new incident, no. If there hasn't been a new incident, then that's going to be a complicated question that we'll have to talk through, because it's going to depend. But so say I thought everything was great and good and I wanted my abuser to move back in, and so I dismissed my order for protection, and then that night my abuser assaults me. I can absolutely file the next day for a new order for protection, and I would base it on the new incident of abuse and explaining to the court what happened, like why I dismissed my order. You're gonna need to give the court some context, especially in your rural communities, because they're gonna be like, wait a minute, why are we just here doing this? Like, what's going on? But technically, as long as there's new incidences, that's never gonna be technically a problem. Now, whether your court will like it is another ball of wax.
All right, that was all of the questions that we had come in.
Great. All right. Do you do the closing, or do you want me to do it?
You can sure do it if you'd like.
All right. All right. Well, thank you everybody so much for joining us. Remember, we are here to support you, so please, please use us. Otherwise, I hope everybody has a wonderful rest of your Thursday. This was recorded and it will be going on our YouTube channel, so please feel free to share it with other members of your staff. Thank you so very much, and for all the amazing work that you do. We couldn't do it all without you. Thank you.